So it was a delight for me to be here.
Ok, dovremmo iniziare a studiare adesso, immagino.
And
Sì.
we should mute that, please.
Allora,
But you know, the
dai,
the
Simone.
first rule of life, il codice del capitale, Professor Pisto will talk about it today. But il codice della vita è always mute yourself and always be aware when you are with your video on, especially for your generation. And the growing debate on the difference, the social and the political and the class difference in our societies, it has become the most important political factor both in Europe and the United States and all the other developed countries, but is making a huge dent now in China too, and of course in geopolitical tensions that we are living. This is the issue that Professor Pistor identifies. Of course, this is the issue that Thomas Piketty made popular a while ago, but if you see what happened in the American elections 16 and 20 and in the referendum in Brexit and in the other main political elections of our time, you see how big this issue is. I'll tell you a couple of things about the book, but since we have the privilege of having Professor Caterina Pistor with us today, I know that we'll say like you start and present your work to our friends here, and then we'll discuss it. Grazie.
Okay. So can we have the slides? So let me just start by saying thank you so much for inviting me to speak here today. Thank you to Louis Press for translating my book into Italian and also to put such a nice cover on the book, which we will see in a second. So I'll just start talking, and we'll go through the slides there, just reminders of what I'm saying, so we can also do it without them. And so the core thesis of my book is that capital is coded in law. Capital has many definitions. Many economists would say it's one of the two factors of production, labor and capital. But of course, you also have to think about sort of how can somebody put capital into the production process. You must have some rights to that capital. And that leads me to conclude that capital is coded in law. You have to have property rights, and you have to have other legal devices that make sure that a simple object, a simple promise, or a simple idea can be flipped into a wealth-generating asset. That's what capital is all about. So here you see the English version, the Code of Capital, and then the Italian, which already discloses a point to which I will come later on, which is who has done it, who has coded capital over the centuries. And I'm basically saying the lawyers, but more specifically in the Anglo-Saxon world, the solicitors in England, the transactional attorneys in the United States, and other transactional lawyers in private law firms in Italy and elsewhere. Also sometimes in-house counsel, of course, but it's basically done in-house, it's done in private firms. I'm not talking, when I talk about the codice, the code of capital, about the codice civile, which is something that is enacted by the legislature. I'm talking about the process of coding capital. Think about software coding, or think about the genetic code. That's the process that I'm talking about, or the genetic engineering maybe. So here, capital is coded in law. Capital is a wealth-generating asset. That's what capital is all about, right? And so we have to understand how can a simple object like land or an idea or a promise generate wealth? Well, I'm saying it can do so because we have law, which is basically the institutionalization of the centralized means of coercion. So the state is very often associated with the centralized means of coercion, but who can invoke these powers? That's the question. And that's what I'm talking about here. So it's mostly the transactional lawyers, as I said. So in my book, I identify actually 6 modules, these are all institutions of private law being the law people use to organize their relationship with one another. Their property law, collateral law, also called security law, trust, the common law trust, corporate law, contract law, and bankruptcy law. These institutions you can observe for 400 years or more doing much of the work of coding capital. And what fascinated me is that we have a continuity of institutions even as the things that we code as capital have changed. It all starts with land, and today it's mostly financial assets or intellectual property rights, intangible property. So we're moving from a very tangible world to a world of intangible assets in which the assets themselves are already created in law and then are dressed up with further legal devices to make them wealth-generating assets. So in the book, I basically illustrate the coding of capital by going through the stories about land, starting with the enclosure of land in England, a phenomenon that we've also seen in continental Europe. I talk about firms, the early partnerships in Florence, the Medici, right? They created a partnership system, which was not a corporation yet, but they tried contractually already to use some of the devices we know from corporate law, namely, if I have a little operation in Brussels, the partners in Brussels are responsible for any losses, not we in Florence. So you're trying to shield the assets in Florence from what's happening in Brussels. That's what the corporate form does, because it creates a separate legal personality. That's what partnership law technically does not really do, but they try to write it in a contract, and actually the courts very often observe that as well. So you see innovation, incremental innovation, mostly done through contracts, transactional work with the help of lawyers, becoming normalized, very often included in legislation, and therefore standardized so that people can use it and harness the powers of the law to code capital. Debt is another asset. You can say credit or debt, depending on which side of the transaction you stand. But having a claim against somebody that you can trade, that you can dress up, that you can enforce against the debtor is also an asset that can be capitalized, not just an empty promise. Without the law, you can tell me all kinds of things that you will give me $1 million tomorrow. It's an empty promise. If it's a legally enforceable contract, then we're talking. You might not have the $1 million, then I will not get my returns. But if you have some assets, I can seize the assets and liquidate them so I can satisfy my claims. And last but not least, know-how. We are living in the knowledge society, so ideas, inventions, copyrights, trademarks, all these kinds of things can also be coded as capital and thereby used to monetize them. So coding an asset, land, firms, debt, know-how as capital is all about monetization, extracting value from them. As you know, Marx said that most of the extraction happens from labor. I don't talk much about labor in my book. Some people criticize this. But what I wanted to show is that actually you can extract value without having labor in the room, because you can extract value from society. Why? Because the code of capital, or the code that is used to code capital, the law, is a social resource. So you're using a social resource, the backing of the authority of the law, to create private wealth. That's an extraction mechanism, as is also the use of money, state money, that then helps bail out the financial system if things go wrong. So we have social resources used to create private wealth. That's the point. It's not just labor, it's also other things. So I have to say a little bit about my conception of law if I talk about coding and about using the law to create private wealth. As you probably have heard before, the sociologist, but also legally trained person, Max Weber, famous person who died in 1920, actually, of the Spanish flu. So he contracted the Spanish flu in his mid-50s and died suddenly, but he had written his legal sociology beforehand, and he had coined the phrase, others have said this as well, that the modern nation state has centralized the means of coercion. But the point is that even if we centralize the means of coercion, which means you can't use self-help to enforce your own contract, you have to go through a court. You can't just go and hit somebody over the head or organize a feud against your neighbors if they did you some wrong. You have to do this through the institutionalized means of coercion, right? That's really what it means. But the point is, even if we centralize or consolidate the means of coercion, access can be highly decentralized. And our institutions of private law give you highly decentralized access to the means of coercion. How? You litigate, you sue, or you just threaten to sue. Or you use arbitration, which can be enforced in a court of law. So the key for coding capital is ultimately to mobilize the coercive powers of the state so that you can tell your counterparty, if you don't comply, if you don't deliver, I will use these coercive powers against you, and I have access to them. That's key. So many people, maybe lay people, think of the law as sort of a vertical thing between the state and the people, either criminal law or administrative and regulatory law, top down, telling people what to do or what not to do. I'm mostly interested in the upper left-hand corner here, how private people organize their economic and social relations with one another, but while using the law. Every contract is enforceable only if you comply with the basic rules of contract law. You have a property right only if you have property, and that's defined by law. It's not very rigid, we can push the limits, but it has to be defined by law to be recognized. Similar for collateral law, similar for corporation. You have to comply with basic principles of the law, but once you have, you can mobilize the consolidated means of coercion. That's how you code capital. So when private parties want to access the means of coercion, they also have to overcome some other hurdles. So those of you who are lawyers who know all about this, we're talking about standing rules. Who can bring a claim in court? Not just anybody. You have to have a right, a legally recognized right. If you don't have a legally recognized right, you can't go to court. We have to decide whether we allow only individuals to sue or also collectives. We have to decide whether we allow only natural persons, you and me, to sue, or also legal persons, corporations. These are all decisions that have been made in law that we take for granted today, but when you unpack the system, when you do what I like to call an institutional autopsy, you're looking inside the machine, you're looking at how the sausage is made, and so you have to disentangle these rules. The next question is, what claims can I bring? Do you have property rights? So very often, for example, recently in a big case against Shell, Royal Dutch Shell in the Netherlands, some 4 Nigerian fishermen brought a case because Shell's subsidiary in Nigeria had polluted their lands and their fishery ponds. And Royal Dutch Shell said in response, you're not really owners. Show me that you're truly exclusive owners, because only then do you have a right. And of course, they're using the ponds, they're using the fish, they don't have the kind of property rights we have. Now, luckily, the courts in The Hague let that pass and let them make the claim, but you see already the first hurdle that you have to overcome. You have to have a legally recognized rights to access the means of coercion, etc. And then, of course, the question is whether the available remedies for this specific right make it worth your while to go to court. And it takes money, resources, and others to actually make it to court. Another issue, and I mentioned this already, so you have a property right only if it's recognized by law. But property, as all other legal institutions, are more malleable, more changeable than most people assume. So economists often argue you have to clearly allocate property rights and the market does the rest. But property rights are constantly refashioned because there is actually no clear definition anywhere in what property is. It's assumed very often because it was assumed that we knew what property was back in feudal times when we coded land. And so the key for lawyers is to create another coding strategy that another asset looks just like property. We're using the technique of analogy or gap filling to invoke the powers that come with property rights. So we used to say property rights are all about tangible assets that we can put our hands on, touch and feel and use, physically use, right? Then we moved in the late 19th century, you have lots of cases in the United States, to protecting expectations of property. So if you run a business and you expect that you will make money, and then the municipality comes and builds a railway through your property or through next to your business, so you have too much noise or your customers cannot come. Do you have a property right that has been violated? Can you get expropriation damages? And they said, yes, perhaps you can. But that's no longer the physical land. It wasn't really about the physics, but it was about the expected returns that you make. And today, financial assets, which are I think, best characterized as a probability to realize some expected returns, also enjoy, in large measures, property rights style protection. So we have basically moved from a property rights regime that was designed to land to apply it to expected value when we talked about going concerns, business as a going concern or financial assets. So I just wanted to read this quote to you, which is was one of the inspirations for me to write this book, by Bernard Rudden, who taught at Oxford for many years legal history, but also Soviet law. And I studied actually Soviet and Chinese law back in 88, 89, just before the wall fell, and studied also the transformation of the socialist world. So he basically said the traditional concepts of the common law of property were created for and by the ruling classes at a time when the bulk of their capital was land. Nowadays, the great wealth lies in stocks, shares, bonds, and the like, and is not just movable but mobile, crossing oceans at the touch of a keypad in the search for a fiscal utopia. And now it comes. In terms of legal theory and technique, however, there has been a profound, if little discussed, evolution by which the concepts originally devised for real property have been detached from their original object, only to survive and flourish as a means of handling abstract value. The feudal calculus lives and breeds, but its habitat is wealth, not land. So we're using the same institutions that protected feudal owners, and we are now basically protecting financial funds. That's his argument, and I think he's right. That's basically what I show in my book as well. So we move from tangible objects to intangibles. I already mentioned financial assets and intellectual property rights. And as I said before, law is malleable. We do not change law just by making legislative change, not even by case law alone. Even in common law systems where we have precedents, we don't wait for precedents. Lawyers are making transactions in their offices every day. And what do? They want to do something new, the client has a great idea, the lawyer has to find the legal solution to make it work. They have to make sure that it doesn't violate the law. If it violates the law, it's not worth anything because it has to be enforceable. So the key for a lawyer is to make sure that you create a structure that realizes the economic aspiration of the client, but is compliant, formally compliant with most rules and regulations, so that it cannot be challenged. And that's a very creative, very complex world, especially when you deal with multiple legal systems. But even within a legal system, you have to think about property rights and contract, bankruptcy law. In financial assets, you have to think about financial regulation. I teach with a lawyer who worked for many, many years in securitization in the city of New York, and she always tells my students, just think of a scaffolding that you build around a building when you try to renovate it. If I look at the existing rules and regulation, I look at them as if they were the scaffolding, and I have to find a gap to get through it. And so you have to find a gap to create a new asset that doesn't hit the scaffolding, then it's void and doesn't work, but it has to work. At least you have to have a high probability that it will work. You can't call a judge and say, will you let this pass? But you can call a regulator. So will you give me basically a pass on this one? You can call the IRS. Will you recognize this? And they will not say this formally, but they will basically give you, in the US at least, something we call a no action letter. It's very unlikely that we ever go after you if you do this, is basically what they're saying. And then they go ahead. And then the only other party that might ever challenge this is another private party who thinks this is wrong. But until a private party finds out that something happened that might not be entirely legal, goes to court, has really a right it can enforce, mobilizes the resource to do so, you already have a couple of years in which you can make a lot of money, and in fact this might never happen. So you have a first mover advantage if you're an aggressive coder. Now, I will complicate this a little bit more. So in every legal system, you have some flexibility of the kind I describe. I say a few words later on about the difference between the common law and the civil law, which is one of the big separations of legal systems in this world. But for now, let me just sort of complicate things by saying, well, we live, of course, in a global world. And you might also even say, you tell us that capital is coded in law. The legal institutions, the modules I gave you, are all modules of domestic law. We don't have an international corporate law. The European Union tried something like this, Società Europaea. It's a partial corporate law, it's not a full corporate law. You have to fill it up with domestic law. All private laws, essentially. domestic law. And so the European Union tried to harmonize some of it. We have some consumer protection law and things like that, but largely moved to harmonizing what I call choice of law, international private law in the continental language, or conflict of law. What does that mean? If you have a case where you have two legal systems might apply, I live in the US, you are in Italy, we want to have a contract, we decide we don't trust each other's legal system, let's have Swiss law govern the contract. And now something happens, I go to a court in the US, will they apply Swiss law? That's the question the court has to decide. And so conflict of law is about this question, when will that court apply Swiss law? Similar, if I have a corporation incorporated in the Jersey Islands, I do all my business in Italy, but I of course do all the accounts in Jersey because I get tax benefits. Will the Italian authorities recognize this corporation as a corporation? That is a conflict of law question. So these kind of rules have made it, over the last 30 years, easier for private parties to pick and choose the rules by which they wish to be governed if they know how to play the game. To put your company in the Jersey, or to put your contract under a particular legal system, let's say the UK, to code financial assets. You can also choose the forum. If you have a contract, you can choose the forum and make sure that English courts rather than Italian courts will govern that contract. And you have a dispute resolution by a common law court, which tends to be more favorably inclined towards private coding strategies. What you may want to make sure is you never ever lose the possibility of enforceability. So what we do when we code assets, we're basically creating priority rights, getting stronger rights than others. We're making rights durable by protecting them from too many competing claims. We're making some rights convertible, especially for financial assets, and we want to have universality, erga omnes feature, to make sure that the rights that we have created are enforceable against the world, not only against our contracting parties, and by any court that might ever sit over them. So here we're coming to who's done it, and this is why I always use, also when I talk in the US or England about the book in the English version, I use the Italian cover now, because who's done it? It's the attorneys, right? And I said before, what I mean really is not the judges necessarily. They very often retroactively sanction what the private lawyers have done. And the lawyers code capital in anticipation that the judges will actually sanction. But even if they have not done this yet, based on existing statutory and case law and their interpretation of regulations, they're trying to code new capital. So these are, in English, we call them the masters of the code. I'm not sure what the Italian translation calls them, but I'm basically saying not they're the masters of capital. This is the clients. But they're the masters of the code because they know the law. They know the scaffolding. They know how to exploit a gap in the scaffolding for creating new types of assets. So they have to know the law. They have to master the law's malleability. They have to be able to translate economic interest into legal concepts, but perhaps even more importantly, they have to be able to repurpose legal concepts for economic use, right? And that's what they're doing all the time. They must be creative, they must be persuasive, and they also must have certain elasticity of their ethical concerns, because otherwise they couldn't push the boundaries of the law all the time. So in a competitive market economy where lawyers make as much money as they do, it's for the clients that they work primarily, even if we're trying to uphold the notion that they also somehow are serving the rule of law. There is a clear tension here, and I think money talks in the end. Okay, so in our global world, most people recognize that we have global financial centers, New York and London still being at the top, Hong Kong, Singapore, maybe Shenzhen in the future coming, of course, closely after them, but nonetheless, they're still at the very top. What people don't talk about so much is that the global financial centers, and I would say almost by definition, are also the global legal centers. This is where the master coders sit. So when you look at the top 100 law firms, global law firms that have offices in more than one country, you will find them all coming from, not only sitting in, but coming from essentially England or the United States. So here I'll just give you the top 13 from the latest data that I found. And what you can see here, there's one company that's called Chinese, but it's actually also a merger with an Anglo-Saxon firm. All of these firms are Anglo-Saxon. They were already in, basically, they were already in a very good starting position when the law changed and more countries allowed mergers amongst law firms. It used to be you had to be a single attorney. Then we allowed sort of larger partnerships. Then you allowed sort of some kind of limited partnerships so they could limit their liabilities. Then we allowed them to have multiple offices in multiple jurisdictions. Then we allowed them to merge. So every step along the way, there's a legal change that enables them, and of course is lobbied for by the interested parties. When you just look at the most profits made by partners, you see this, it's entirely Anglo-Saxon names that make most of the money in this world for advising their clients. So I said before I wanted to just to say one word about the legal origin debate. There has been a big debate time and again, mostly led again by economists over the last 20 years or so. You might have heard about the law and finance papers by Laporta, Lopez de Solanes, Schleifer, and Vishny, who empirically showed in a series of papers since the late 1990s that the common law is highly correlated with the development of financial markets. So countries that have the common law have more liquid, better capitalized financial markets than do civil law countries. And they say, well, they better protect property rights. What I am basically saying, it's not so much about better protecting property rights. What the common law allows, more so than the civil law, is coding of capital, pushing the boundaries of property rights, creating new types of property rights that will be recognized by the courts. How so? Because it's a system that is not as codified in terms of statutory law, it's not as rigid as the civil law, but also the underlying principles are not as rigid. So the civil law really has a clear-cut separation between contracts, an exchange relation between two equal parties, and property rights, which is a relationship of a party to an object in relationship to everybody else. And it's clearly policed in the civil law system with the legal institutions we have. The common law has busted that separation mostly through an institution like the trust and other devices and is more amenable to the coding strategies that I described. Plus, also this is really important, in the common law system, judges are recruited from practicing attorneys. So you first practice for 40 years as an attorney, either a litigator or as a transactional lawyer, and then you're recruited to the bar. Whereas in the civil law system, you go to the bench, become a judge right after law school, after some additional training in some jurisdiction, which makes for a more bureaucratic kind of mindset, less amenable to what the lawyers will tell you. Okay, so I come to my conclusion now. So I think there are a couple of things that we have to think about when we look at the coding of capital, and I want to link it to also. I'm arguing in the book, capital creates private wealth. It uses a social resource, the legal system, to create private wealth. And it also thereby creates inequality, because not everybody has equal access to the legal devices. You can just look at the salaries that lawyers make, the hourly rates that they charge, to get a sense for who can afford it or who cannot afford it, right? To really take advantage of tax paradise, things like the Pandora Papers recently talked about again, you must have a couple of million. Without that, it's not worth hiring a lawyer, right? So or you have to have resources to avail yourself of the legal powers that our legal systems afford. So that, of course, creates this tension to some extent with our notion also as democracies that we use law to self-govern. We're self-governing complex national systems through law. We have a constitution, we're enacting legislation, we have budgets, we have tax laws, we have regulatory laws. We also have the civil code and other legislation that can be changed over time. So we're governing ourselves through law based on some shared norms. That's the idea. We have created a system which allows not only some private parties to finagle the law in their interest, but also to opt out and opt in freely. Whether or not they do, you can take English law and still do business in Italy, you can take Cayman Island law and still do business in Italy, and it's recognized and enforced by Italian courts, which basically gives some the option to pick and choose the laws by which they will wish to be governed, and to be outside the realm of a democratically elected legislature. That's a problem. I think that's a problem, and I think when people have problems with our democracies right now, at least one reason I would say is that they have a good intuition that they have lost control over their future, because they don't control much of the economy anymore. They don't, because people can pick and choose. So what is to be done? You know, что делать, as Lenin asked a century ago, what is to be done about it? So in the book, I'm arguing for a series of more incremental reform changes. This is a very complex system. There is no silver bullet to change it completely. You can't do this. Some people argue maybe it just has to crash and we rebuild it from the ashes. I don't really like crashs because you never know how you get out on the other side. And plus, we just don't know wouldn't the coders survive and do the same thing all over? We don't know, right? So we have to be more mindful and strategic about it. And so I think we have to find the soft spots, the spots where capital really benefits from the social resource called law. So I think we have to push back the option to take foreign law and still be doing business here. So the ability to pick and choose one's laws, I think, has to be curtailed. So has the ability to use private arbitration rather than courts, because under existing rules and international convention, if you have an arbitral award, even from a foreign arbitral a tribunal, you can enforce it with the courts in the countries that belong to that convention. So you can bypass any kind of scrutiny by national courts and institutions to make sure that it's compliant with norms, only if there's a fundamental breach of what they call ordre public, public policy, which must be really the very deep morals of a society, can you question arbitral award. And I'm basically saying we have to push back against that as well. And we, of course, have to be much more mindful about the extent to which the legal institutions I described, the modules of the Code of Capital, allow private parties also to externalize the risk and the costs of what they're doing. So limited liability of a corporation is a license to externalize. And I think in a world where we face climate change, we just have to rethink some of these privileges that we created at a very different point in time. So I want to stop here. You can ask about other strategies. I know this is all rather complex, and maybe these incremental changes don't add up too much in your mind. I sort of agree, so I'm basically trying to push in my recent research further and think what else could we do? What are really sort of more fundamental changes we should implement? But this was basically my first cut. So thank you very much. I appreciate your attention.
Thanks very much, grazie, Professor Katharina Pistor, for such a wonderful ride through her book. In the meantime, la dottoressa Dentico si è unita anche a noi, saggista, scrittrice, e direi, se tu fai il tuo intervento, diciamo che abbiamo adesso una quarantina di minuti e poi sentiamo anche se ci sono domande, eccetera. Prego.
Buongiorno, in inglese o in italiano? In inglese. In inglese, that's much better. Okay. Good morning, everyone, and sorry for my delay. There was a misunderstanding about program, and I really apologize for not coming earlier. I would like to actually build on the final slides of Professor Pistor, whom I have listened with great attention, because I will kind of follow her with my perspective, which is a very real life perspective, health, the right to health. And what capitalism has done, is doing, and will do to health and the right to health, if we don't dramatically change the course of things as they have been depicted, as they are today. I think I'm more slightly audacious than Professor Pistor about the idea of changing a system that COVID-19 shown is a profoundly rotten and dysfunctional and pathological system. This type of capitalism, turbo-capitalism as we have it, is not a system that will actually provide any real, hope or hopeful scenario for the future unless it changes dramatically. And I think health is a very, very, very provocative, but also a very insightful lens to see how we have come to this and what has happened to the world from a health perspective through such a neoliberal and deregulated capitalism, and how things are being, in a way, prepared and tabled for the future. next week, on Monday, I will be in Geneva as one of the few Italians, following a very important negotiation which would address capitalism after COVID-19. Actually, it's a process, it's a diplomatic process, being here at the Festival of Diplomacy. It's a diplomatic process which hardly you, maybe, or people, or the media, or civil society organizations, or the policymakers are aware of. And if they are aware of it, it's basically to stop it. This is the 7th round of the negotiation dealing with the creation of a binding treaty to regulate transnational economic actors when it comes to the rule of law, when it comes to international law, human rights, okay? It is clear, I think, to everyone that for decades of capitalism, where the only rule was the removal or the absence of the rules, which is particularly serious and particularly impactful when it comes to health, and I'll get back to that. It is clear that regulating transnational corporations and moving beyond this, how shall I call it? Now it's really become an ideology of social responsibilities of the private sector, trying to avoid, in the end, the legal responsibilities of the private sector, because this may occur in some countries, but it is certainly not the case for the vast majority of countries and people and victims, affected, survivors of catastrophic events provoked by the private actors in the global south. Regulating these actors and recognizing them as agents of crimes against humanity, as, for example, now more and more even the environmental crimes are asked to be recognized. Crime against humanity is certainly what in technical terms we would call the elephant in the room. It is the huge missing tool in international law that is not addressed. And as I said, when we are trying to push for this treaty, when we are trying to advocate for the, at this point, indispensable value of such a treaty, basically we are considered some sort of agitated folks that don't really have a sense of reality. This treaty-making exercise started from Ecuador and South Africa, two countries that are heavily affected. They were heavily hit by the devastating action of especially the mine companies in their own respective countries, and Ecuador particularly with the Exxon Valdez case, the devastation of the tropical forest. Now, people in Ecuador, after 25 years of legal avenues and experiences and efforts, are not yet able to receive the justice and the compensation for what has happened to them. This is the origin, the spring-off of that treaty. But, as we were informed 2 days ago, Europe will not attend this treaty negotiation next week. They have tried to boycott it many times in the past because, according to Europe, the negotiation of this treaty, quote, would be against some of the European regulations and legislative tools. Is this the type of Europe that we want? I don't think this is the type of Europe that we desire and that we have been, expressing our aspirations for, okay? On top of Europe, which is, of course, a major stakeholder in this process because many of the companies creating a major impact around the world are European, but of course not only European, other major stakeholders are the US, Brazil, China, and they will all attend. Europe will not go. Now, if this is a kind of an indication, a signal for the capitalism that we want to create for the future after COVID, if this is a reaction to COVID or to the feeling of a push for something new coming after COVID, this is very, very worrying because in the meantime, Europe, and only Europe, is very active in pushing at the WHO, at the World Health Organization, a new tool, a pandemic treaty, to officially, respond to the future pandemic. This treaty was announced, the idea of this treaty was announced last January at the executive board of the organization, of the World Health Organization. It came top down, totally unannounced. It was, it was a bit of a surprise. And actually, it took a little bit by surprise. So people like me, who I belong to the civil society organizations, we, as I said earlier, we are very strong advocate of binding arrangements. We don't, we are not satisfied with only soft norms or with elements that are basically legislations or juridical tools that are basically voluntary tools, okay? So we were kind of put in a cul-de-sac, a bit of a corner, because he said, why? How come this treaty? There is already a binding treaty at the WHO to deal with emergencies, health crises, including pandemic crisis. And one wonders why we need another one. We would like to see at the WHO in-depth analysis of why, as the WHO independent panel asserted in its report last May, all countries in the world, all the 196 member states that are parties to this treaty, the International Health Regulations, which is a long-standing juridical tool of the WHO, dealing with, in a way, the reason why the WHO was created, dealing with emergencies, tackling diseases, and being able to organize and coordinate action against health emergencies. This tool was created in 1969. It was revised in 2005 after SARS, in 2002. It came out in the new version in 2005. And it is the highest ratified, highest agreed upon treaty in the world. It has 196 member states to it, okay? The WHO independent panel has declared that during the arrival of the tsunami of COVID and during the first part of the first phase of the pandemic, clearly most countries, including the WHO in a way, breached this agreement. They violated the international health regulations. The WHO should have been listening to the CDC of Taiwan, the Center for Disease Control of Taiwan, which on the 31st of December already warned the WHO about human-to-human transmission of COVID, of SARS-CoV-2 at that point, of a new pathogen, of a new virus, which no one knew. The WHO didn't even reply to Taiwan. Why? Because in the geopolitics of the UN, Taiwan belongs to the Great China. This is, of course, an arrangement that the Security Council has endorsed, and it is clear that WHO is in a kind of embarrassment on the one hand. Every year, you may want to go to every single WHO assembly. I've done that. This is my disease over the last 20 years. And you will see that the first day is dedicated to addressing this question of Taiwan. Because can we really respect, strictly speaking, geopolitical assets when it comes to health? Can we? That is why I said that the right to health is a terribly meaningful lens criterion to address whether capitalism has functioned in the past, whether it is functioning in the thinking of the future today. By the way, the international community is filling its kind of meetings, the blah, blah, blah that Greta Thunberg evocates, with some of the mantra that are, one of which is, apart from leaving no one behind, and we'll get back to that, but building back better. It's not building forward better. They can't see the forward in a way. Policy makers, you may think this is just a word in English. No, I think it's a political projection. Building back better means that you're still looking at the recipes of the past that have shown how dysfunction, how pathological and how many pathogenesis they create. Spillovers. We've had several spillovers since the beginning of the new millennium. We've had at least 12 serious spillovers, starting from SARS, MERS, avian flu, swine flu, you name it. Ebola, which was classically a very circumscribed, geographically limited virus, almost became a pandemic in 2014 and 15 because of a globalized system where we are all interconnected. And whereas in 2002, maybe, you would not have the lorries passing by the villages where Ebola sprang off, now you do have such event that maybe a lorry driver in the routes to the capital brought the Ebola virus to the capital, and then it went elsewhere. Anyway, let's go back to this idea of the pandemic treaty, because ignoring, not having a serious understanding of why governments, member states of the WHO don't respect, don't abide by the binding instruments that they have accepted and ratified, why on earth do we want to create new ones of the same kind? And the WHO, whose Director General opened his arms to this idea coming from Europe, mainly, I guess, because he needs to be re-elected next year, and there's nothing better than a treaty negotiation to secure that you will have a second mandate. The WHO literature and the European Union literature, they happily claim that this new treaty will have to be negotiated in the presence of the private sector. With this idea that is very soothing, I must admit, I'm a journalist, as a journalist, I'm sure that Lyotta agrees with me, when you hear this kind of evocation of the all of government, all of society, you feel good in a way, no? But all of society, it's a bit of a trick mantra through which they will imply, without you being totally aware, that those that have provoked the problems will be part of the negotiation. So all of society, in reality, is not all of it. It's the fact that you will now have at the WHO the representation of this asymmetry of power, which creates exactly what Professor Pistor mentioned earlier, and for which we need to restrict, limit, do this kind of shrinking of their power exercise. Otherwise, the governance of the world is not going to function, and actually is going to go in a very dangerous direction. There will be a special assembly of the World Health Organization at the end of November to decide about this treaty. I'm involved in a research to basically put this idea of the pandemic treaty, because apparently the world, the policymakers, the international community can only see itself in a pandemic future, okay? It seems to me that this pandemia has become a sort of a destiny, which partly it's true, but it is also clear that the international community has surrendered to this scenario as if we could not do something now, as if we could not have done something also last year to start changing the route of capitalism during COVID, learning the harsh, ferocious, but rational lessons that COVID-19 has given to us to really create a new governance system, to create a new scenario, okay? No, they are imagining that this emergency, which is a perfect condition for some of the economic players, from the financial players, from those pandemic profiteers that are the same ones of the various papers that occasionally emerge, but are the ones whose amount of money has dramatically increased because of the COVID emergency in 2 years, by the trillion, not by the billion, okay? Let's see how this pandemic treaty will be dealt with. For us, as civil society organizations who are favorable to binding agreements, this treaty is not to be done. It's not convincing at all. Why? Because treaty making are usually a bottom-up exercise. They come from academia, they come from, yes, okay. They come from civil society organizations, they come from those that are the expert of the subject, not by the president of the European Council or by a few leaders from the top. Treaty making, as Professor Pistor knows very well, are long processes. They want to have a treaty in 1 year. It's going to be negotiated while the pandemic is still going on. So why are you projecting yourself to the future instead of looking at things now? And also, what is this pandemic treaty that basically provides only biomedical solutions, innovation, pharmaceutical ideas, whereas the problem is anything but pharmaceutical? The problem is that, as COVID-19 tells us, health will not, global health will not, cannot be addressed in the same, with the same framework that has been dealt with today. Disease by disease, vaccine by vaccine, diagnostic by diagnostic. Here, what COVID tells us when it comes to capitalism and health is that we cannot confine ourselves to looking at the human health without looking at planetary health, animal health. So we will have to have finally a one health approach. That is to say that human health needs to be harmonized with the way that animals, livestock are being managed. And basically then we have to get rid of the industrialized approach, the industry of animal livestock and the industry of agriculture that is based on pathological instruments like antibiotics and pesticides, because these are major problems to health. And that is, in a way, what capitalism has produced to health in the past. We usually talk about the social determinants of health, but we never enough talk about the industrial determinants of health. Not only in the mine industry, but definitely in the agriculture industry, in the livestock breeding industry, in the environmentally, dangerous industry. The other thing is that we say, why do you want to negotiate a pandemic treaty if you don't take into consideration seriously the idea of regulating the private sector, of regulating transnational corporations, and you actually invite them to be part of the negotiation board? Apart from the conflict of interest, which no one talks about anymore because it has been completely nullified, it doesn't exist anymore since in 1999, the Global Compact was adopted at the UN, which was de facto an institutionalization of the private sector role in the policy shaping at the UN. So much so that we had a World Food System Summit in Rome and in New York a few months ago, last month, that was basically in the hands of the agribusiness industry. This has been declared even by the rapporteurs of the UN on the right to food. 3 of them disclosed this conflict of interest intrinsically enshrined in the very organization of the summit. I see here 2 major problems, and I'll come to an end. We are today in a situation that is very, very complicated in terms of multilateralism, the threads of multilateralism seem to be broken. It is very difficult to make decisions in an emergency time that are quick, fast, and responsive enough to the needs. Moreover, we have been damaged in diplomacy making by 2 years of Zoom multilateralism, which only, in a way, reproduces and enhances the geopolitical asymmetries, the asymmetry of powers that objectively exists in the world. It's always existed in the world. We are, on the one hand, in a situation where governments seem to be kind of lost. And governments, during COVID time, are still in the midst of the crisis management, many of them. There is still, we are talking about the third dose, about the booster dose here, but as you know very well, although we don't speak so much about this situation today because we are covered, 90% of the Italian people, of European people are almost covered with the vaccine, but this is a situation that doesn't exist in the global south, where 4% on average of the population have been vaccinated. There are many countries in the global south where even the health personnel have not yet had their first dose. And out of the 6 billion of doses that have been produced, there are about 100 of them that will actually, that will actually, be thrown because they have expired. Absolutely. So we are in a situation of multilateralism, a broken multilateralism, and we are in a situation of the so-called multi-stakeholderism model. We are in a situation where the governance of the world is in the hands of multi-stakeholders, a myriad of different actors that are convened around the same table as if the world were flat and if we had the same stakes and we were around the table to discuss health, food, energy, finance with the same interests. So I think COVID came as a great pedagogist to tell us that we need to change. I hope in your questions we will come back to the question that Professor Pistoro hinted at, the question of the trade agreements, about the management of knowledge and the knowledge economy that is really one of the major drivers of asphyxiation of the capitalist world today and of science itself. Thank you.
Grazie, grazie Nicoletta Dentico. I think our streaming is running off. The friends here, the organizers told us around noon, so I'm skipping at my remarks and trying to see if you have questions we can hear, or at home we can collect them now. Anybody? I don't know if somebody online has questions. Okay, in that case, while you're gathering your thoughts after these two impressive speeches that we heard on the issues we're discussing today, let me just give you a couple of points and that we can discuss together. And this is a book, il Codice del Capitale nella traduzione italiana, that is quite interesting because you can tackle it from very many different point of views. First of all, I have to congratulate my friend Daniele Rosa because, as you know, or some of you may be aware of it, Luis University is connected with Confindustria, this association of the Italian entrepreneurs and companies. So it's great that Luis translates such an interesting book discussing the core that is now keeping together, as Nicoletta discussed too, our societies, our markets, our civil institutions, and our democracies. there is a wave of change that is quite important, and it has been going on for quite a few years now. And if you read this book, as my colleagues at the School of Law will, in reading some of their notes, Pistor books, I believe, is a welcome and great example in line with the tradition of institutionalists such as Adolf Baer, Robert Lee Hale, Thorstein Veblen, and the above-mentioned John Commons, the old institutionalism debate. And this is Professor Massimiliano Vatiero of the University of Siena. So read this book if you are interested in being a lawyer or being a judge or being a scholar of the law. And we can indeed read this book as debating the philosophy of law, as we would have said when I was a student, the philosophy of law. On the other hand, this is a very important and interesting book to understand what's happening now in the world. Because there are many people that do not, both in the United States and in Europe and in developing countries, that do not accept the social contract anymore. Alec Ross, former advisor to Secretary of State Hillary Clinton, recently wrote a book saying our social contract is broken. But while Alec Ross denounces this from a political point of view, Professor Pistor analyzes why the break in our social contract not only doesn't, excuse me the pun, break any law, but is embedded in our laws. And this makes very difficult for people to challenge it. While I was preparing for these wonderful discussions today, I could not escape the fact, as you all are very aware, is that the Italian political debate a couple of weeks ago was mesmerized by a very arcane and very abstruse and very difficult for people to understand debate, because we have to update our catasto, and catasto is the land registry, okay? And this is something that is pretty basic. You have to do it because today in Rome you may own a small apartment in the suburbs that were built in this century, 5 years ago, 6 years ago, and pay real estate taxes, local real estate taxes, and the value, of course, is very low, but your taxes are comparatively very high. While if your family, and I have many, many names now crowding my mind that I'll skip for the sake of this important discussion, if your family bestowed you like 2 floors on a great palace in the city center of Rome with frescoes from the Renaissance or stained glass, you may pay comparatively very, very, very little taxes. And of course, you could be able to borrow a lot of money, and you could be able to do a lot of things with that patrimony. And when we decided to normalize this and to bring this not to any kind of a revolutionary upgrade, but to make it updated to the market laws, there was a terrific debate, and people said never, this is like robbing people, and even our prime minister had like to sidestep and decided to tune down the reform, and it was not such a great idea. And this is what this is why this book doesn't. It is a scientific book. It is a scholarly book, but it's like sticking the finger in the real debate that we are having today, and there is no escape out of this. look at what's going on in the United States, and look what's the debate on how the money of the next stimulus are going to be spent. And when you see that the law, instead of being the referee and the just referee between citizens in the community, is stacked up to defend the status quo, we come, and I finish, we come to, also I want you to have time for a little conclusion on what Nicoletta said. This comes to a very paradoxical conclusion, because, of course, Thomas Piketty and many other scholars and writers are debating this, and have been debating this for quite a while now. Please mute whoever still is on, always mute yourself, it's the mantra of our time. The still dominating ideology in the developed world is that the market is fair, and that you cannot, go against the market. And people believe that. And if you look at the history of development since the end of World War II, you'll see that the market spread wealth for a while, and reduced poverty in the world for a while. But especially when it comes to your generation is keenly aware that there is so much stacked against who is under 30 in the world today. It doesn't matter if he lives in the developing countries or in the developed countries. And it's very tough, and you need hard work and lots of luck to check and to compare to the standard of living that your parents, your great-parents had. And so we have to work on that. We have to work on that. Because if we don't work on that, what's going on is a growing disconnect with the law. If you look back, I'm finished. If you look back at the history of Europe exactly 100 years ago, in the 20s of last centuries, I wasn't born, I promise, you'll see that what happened is that people got disconnected from democracies, from the belief that there was any fairness in the institutions. And the great totalitarianism in this continent, both fascism and Nazism and communism and Stalinism in Eastern Europe, were born when people believed that the system was stacked against the little guy, and very often the system was stacked against the little guy. And very often the code that Professor Pistor is analyzing today was a code that, if we can say, Catherine, it was a feudal code. It was a feudal code. The code was enshrined in the law to record and to grant that workers, women, minorities were excluded from the benefits of growth. What is fascinating for me, especially when the part of my time that I spend in Rome, that is, of course, a city where history is embedded every turn that you make driving your car or driving the bus, we learn in school that the Middle Age and feudalism is over. I mean, it was not even a discussion. But then you drive around Rome and you see that the Roman Empire and medieval age and Risorgimento, all the different monuments. The same is true for the law. The same is true for the economy, and the same is true. There are still, what is beautiful to discover, or terrible to discover reading this book, is that there are still basic tenets of feudalism that we read in school when we were in high school, and we thought like how boring. This happened like 6 centuries ago. It's happening now, kids. It's happening now. Grazie. Grazie Caterina Pisto, grazie Nicoletta. Please.
So thank you very much for both of your comments. Let me say a few words about the health issue, which I think is really a very critical issue. And last night when I looked through my Twitter, I came across a tweet from Politico, which had put their hands on the contracts that Pfizer, one of the big pharma companies that marketed the BioNTech Pfizer vaccine, had concluded with different governments, just to see also how sovereign states contract with pharmaceutical companies. Secrecy. You cannot tell anybody about the contract that we conclude with one another. Risk shifting. If anything happens with the vaccine, you share the risk, we don't. And when you go through the contractual provisions, which they, which were just disclosed, there was a leak or something, you see a highly uneven bargaining position between a private corporation. And just remember, a corporation is a creature of the law. A corporation exists only because the law says if you put some people together and they comply with some basic rules, you create a separate legal entity. These legal entities have become a little bit of a Frankenstein monster, if you want, that now set the terms for sovereign states under which they are wishing to give them a vaccine on which they depend. So in addition to what you're saying about international and multilateralism, these are attempts by sovereign states to get to grips. And of course, that is being eroded to some extent by participation and lobbying of major companies. But at the same time, we also have direct contractual relationships between sovereign states and these companies, which again have a highly uneven bargaining feature to them. And that I think is deeply problematic. It goes back to what you said at the end. The feudal calculus lives and breathes, as Bernard Rudden noticed already in 1994. And there's a historical reason for that, and it just clicked with me when I read recently another great book by Jonathan Levy, Stages of American Capitalism. And he said in the one chapter just, America was first capitalist and then democratic. We all were. We all were first capitalist and then democratic. That's the seed. Because we basically have transposed some of the private law institutions that long precede our constitutional democracies into our private law, have embraced them, and they have basically it's a parallel. It's like shadow banking, about shadow banking. It's like the parallel legal system that to some extent we also need for a private market economy. You have to have sort of a low-level system that is decentralized and can be adapted, but it has grown out of proportion, and that's basically my message in this book.
Nicoletta wanted to
Yeah, just two things. The first thing is that by paradox, in 2019, so before, just 1 year before COVID, a few months before COVID, the WHO had passed a resolution which in a way imposed transparency in governments' negotiations with the pharma sector, because governments are good investors. When you negotiate a price or negotiate for any tool, any medicine, with the pharma companies, you should have, as we say in Italy, the knife on the right side, and you should have the capacity to leverage. So why should we transact in a reserved or secret fashion? How do you explain the price of this drug? What is its therapeutic advantage if we're talking about a drug? What is the patent status? A series of things. The negotiation of any government, especially in the North, I mean, we are more conversant with the US and Europe, with the pharma sector, as Professor Pisto said, has been carried out in a way as if this resolution, which is soft norm, did not even exist. So memory, very short. The second thing is that multilateralism now, I think, will suffer a lot. I mean, we'll go a very delicate phase, and this will all happen in the next few weeks, because we have been discussing now for 2 years the idea of using a tool of international law which is embedded in the WTO treaty, in the Marrakesh Agreement, and that is the possibility of a temporary suspension of intellectual property rights. So the IP waiver, the intellectual property waiver, that is a perfectly provided rule of the game. It's a perfectly binding rule of the game. Of course, there are now more than 110 member states of the WTO that are in favor of this waiver, and only a few, namely Europe again, that is mostly blocking the whole thing. At the end of November, there will be the 12th Ministerial Conference, and a solution will have to be found there. If this small amount of countries that are Europe do not accept what the vastest majority of countries, even the US at the last meeting told Europe that history is looking at you, we are really going to put the world and multilateral gameplay in a very serious position. So there is this knowledge economy which will be, I think, a very discriminant factor. The way that we will select and think something new for the future will be a very discriminant factor for the capitalism that we will be able to build and the scenario that we will be able to build for the future after COVID. Thank you.
Grazie Nicoletta Bolsico e grazie Caterina Pristo, grazie a voi.